Alex here with an events video on Swalinkavich versus Swalinkavich, an appeal on a modification of custody and order allowing mother to relocate to Virginia with her daughter. District Judge Cheryl Moss originally heard the dispute in 2016, at which point, partway through a bench trial, the parents decided to condition the custodial designation and timeshare on whether or not mother ultimately decided to relocate to Nevada, wherein if she did, parents would enjoy joint physical custody, and if she didn't, the father would be awarded primary physical custody. Prior to making a determination on whether to move back to Nevada, the mother filed a motion to modify custody. Ms. Moss held an evidentiary hearing and changed her mind, deciding that mother's pregnancy with a new boyfriend and father's refusal to allow her to have some of his visitation time constituted a change in circumstances. The father filed an appeal, emphasizing a report prepared by Dr. John Paglini, an expert who evaluated the parents and expressed concerns at the notion of awarding the mother primary physical custody, which was ultimately considered by the parents in coming to the prior agreement in the first place. The mother responded that the court's consideration of the best interests of the child were sound, specifically citing the Virginia school system as well as testimony and evidence supporting the father's harsh treatment of the child. In replying, the father pointed out that all of what was relied upon under the best interest factors was already known and considered prior to the earlier agreed-upon decree, and that the change of circumstances cited by the court was in violation of Nevada law and an abuse of the court's discretion, namely that the legislature contemplated the importance of keeping siblings together, not half-siblings, and that the court's interpretation could be abused by parents seeking to create a change of circumstances by creating new children with subsequent partners, and that a judge abuses its discretion when awarding visitation to one parent only to punish that parent later for refusing to relinquish the visitation time specifically allocated to him or her. We filed a media request, and Chief Judge Michael Gibbons has granted that request, allowing us to broadcast live from the Court of Appeals on March 24th at 11 a.m., where Court of Appeals Judges Bonnie Beulah and Jeremy Tao will join Mr. Gibbons in presiding over oral arguments. The father is represented by Elizabeth Fleming. The mother is represented by Aaron Grigsby. You can keep up to date on our media coverage at www.ournevadajudges.com, and as with our previous videos, feel free to post any questions you have down in the comments below, or you can send us an email at admin@ournevadajudges.com.
Pursuant to that Supreme Court ruling, your death penalty qualified.
This is the time set for your hearing on custody.
Any statement that you make is under penalty of perjury.
No, that's not how it works.
We will take this case under submission.
That would require proof by very significant evidence.
You both did a good job bringing all this to my attention.
I'm going to make a record about you in a minute. You need to sit down and be quiet.